Hello, everybody. We'll get started in just about a minute. Hello, everyone. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. I'm delighted to welcome you all to the next installment of the LI's monthly PFAS briefing series. This month's topic is hazardous substance designation, and we have some great speakers joining us today. I want to take a moment to thank all of them for taking the time to prepare some wonderful content for this session. Our speakers will be taking some audience questions later on in the program. Please don't wait to submit any questions that you have them. You can use Zoom's Q&A function at any time throughout the webinar to pose your questions, and our moderator and speakers will be able to see your question. We encourage you to use the chat as well for any observations and comments that you have, but please be aware that we'll be pulling discussion questions from the Q&A box at the bottom of Zoom's interface rather than the chat. Today's program will be recorded and uploaded to the event webpage for members to view later. So if you're an ELI member, be sure to check back within a couple of business days for that recording if you're unable to watch the full program. Now, before I introduce our wonderful moderator for today, James Pollack. James is an attorney at Marten Law, where he leads the firm's consumer products regulatory practice. He helps consumer products manufacturers in the apparel, outdoor gear, furniture, and food products industries who are working to understand the complicated and shifting regulatory and litigation environments surrounding emerging contaminants. As the lead author of the PFAS Desk Book, he has gained extensive knowledge on PFAS regulatory compliance at the federal and state level. James, I will go ahead and hand things over to you. Thank you so much.
Thank you so much for the kind introduction, and welcome everyone back to the monthly PFAS briefing. This is part of the Environmental Law Institute's ongoing programming related to the PFAS Desk Book. We're so excited to have this panel for you today, where we'll be talking about a really exciting topic and probably timely topic, as this could happen any day now. The impending EPA hazardous substance designation of two of the most widely detected PFAS chemicals, PFOA, PFOA, and PFOS. With me today, I'm very excited to introduce Christine Santillana, Legislative Counsel for Healthy Communities at Earth Justice, as well as Jean Zhuang, Senior Attorney at the Southern Environmental Law Center. These are two folks who have really wonderful knowledge on the policy implications of this designation, a lot of the discussion of how this designation will impact a number of industries, as well as how this will inform the cleanup of communities throughout the United States. So really happy to have them here with us today. With that, I'm excited to dive into the actual substance here, no pun intended. Now, the pending regulation that we're discussing today was first proposed back in September of 2022. And the proposal of designating PFOA and PFOS as hazardous substances under CERCLA would have some pretty broad implications. it would trigger all of the requirements under CERCLA that many of you are probably familiar with. Things like the reporting of releases of those substances in order to provide timely information for response. Of course, it creates the authority for regulators to respond to those releases, as well as the threat of releases of those substances through cleanup actions. We also have the triggering of cleanup liabilities, the ability to spread the cleanup costs among all of the PRPs, which can lead to, as I'm sure many of the attendees are aware, a lot of litigation, as those cleanup costs are ultimately allocated among the PRPs for the relevant site. And I think one of the pieces that's particularly interesting to folks is the possibility of reopeners, the possibility that PFAS is commingled with other substances at existing Superfund sites. Something that I will probably bring up during this webinar are a number of Superfund sites at around military facilities. These are existing Superfund sites where PFAS has been detected, and now the cleanup there, the response there, will have to be adjusted in order to account for those substances and the detection of those substances. Now, the proposal, as I said, was back in 2022. There was an advance notice of proposed rulemaking in April of 2023 to gain comment about the potential listing of 7 additional PFAS. But we anticipate, and EPA announced the plan to release the designation of PFOA and PFOS in March of 2024. Here we sit at the end of March of 2024, and it hasn't been released yet. It's part of why we scheduled this webinar for this month. But it could happen any day now. With that introduction, Christine, I'd love to bring you in here. Tell me a little bit more, or a little bit about Earthjustice's efforts in this space. How does the organization view this hazardous substance designation, and how is it informing your work?
Yeah, well, thank you for the question. I just want to first quickly say hello to everyone joining us, and thank you so much for your interest in this incredibly important topic and for making time to be here. But to answer your question, so Earthjustice has been advocating for EPA to designate PFOA and PFOS as hazardous substances for several years now. We did also submit comments on the proposed rule and are very much in support of EPA taking the initiative to designate these 2 most infamous PFAS under CERCLA. I do want to emphasize how important this rule is. As James discussed, it'll give communities and states and federal regulators these tools that they wouldn't otherwise have in order to start investigating and cleaning up some of the most contaminated sites, and while holding polluters accountable. It will help relieve taxpayers financial burdens, will also provide incentives for responsible behavior and best practices among industry and different sectors. Earthjustice takes the perspective that this rule has been long overdue. And our work is really centered around our partners, our clients, and impacted communities. And currently, it's those communities that are facing and bearing majority of those costs, many with their health, incurring medical costs, being hindered from just living their lives because of serious illnesses or medical conditions due to pollution from PFOA and PFOS, and by no fault of their own. So we believe that there's no reason why the federal government should wait any longer to take this action. And I'll just also add that Earthjustice will continue pushing EPA to take a class-based approach to provide more expansive protections, but we are certainly grateful for the agency's efforts and support these particular designations.
Thank you so much, Christine. And I'm really glad that you raised that class-based versus chemical-based approach. It's a really interesting feature of PFAS that was raised during the first webinar and led to some healthy discussion about how these environmental laws can adjust to the reality of this family of chemicals versus individual chemicals within that family. It's a theme that I think will be raised at every webinar that we host. So I'm really glad that you brought it up. It's good to see these themes cross-cutting across all of these webinars. And Jean, Christine did such a great job bringing Earth Justice's perspective here with your regional-based perspective. Would love to hear a little bit about how SCLC has been active on issues related to PFAS and how you're thinking about this designation.
Yeah, of course. As you mentioned, we work throughout the Southeast, kind of on the ground, working with communities that are suffering from PFAS contamination, and also at the federal level on PFAS issues that will have a national impact. And because we have done a lot of work on the ground, we've seen a lot of the devastation caused by PFAS pollution in our region, starting with the Comores PFAS manufacturing facility, which many of all might have heard of in Fayetteville, North Carolina. We found out back in 2017 that DuPont and Comores had been dumping these chemicals into the Cape Fear River for 40 years and had polluted the air and the drinking water and the soil for over 500,000 North Carolinians. So, our work really started with that facility and expanded as we continue to find more facilities that release PFAS over the past several years. And our work has focused on protecting communities by stopping PFAS at the source. And, that might look like Comores, an industry like Comores that's dumping this stuff directly into our rivers and drinking water sources. It also might look like an industry that is releasing PFAS into a city's wastewater treatment plant, where these plants really aren't built and not equipped to handle industrial pollutants like PFAS and can't remove them. And over the past several years, we've learned a lot from our work throughout our region, mainly that crises like what's happened in North Carolina and with Comores can be avoided. And this is because the Clean Water Act already has the tools that we need to stop this pollution. First, I just want to point out that states and EPA need to begin requiring dischargers to disclose any PFAS pollution in their NPDES permit applications, so that groups like us and Earth Justice and our clients or community groups aren't the ones that are having to identify where this pollution is coming from, and that polluters are self-identifying and self-reporting if they are releasing PFAS. And second, our agencies need to be, our permitting agencies need to begin implementing case-by-case technology-based limits for PFAS and permits. And these simple tools that we've seen work already in our region, they are already requirements of the Clean Water Act. And with these simple tools, states and EPA can both identify and control PFAS pollution that's getting into our rivers. It's also the fair outcome, because it would mean that the polluters would be the ones on the hook for cleaning up their pollution and not our communities. So, a lot of the work that I've done has been in this Clean Water Act space, but I'm excited to be talking about CERCLA today and how we can use another essential tool to ensure that those that are responsible for PFAS pollution are the ones that are paid to clean it up.
Thanks so much, Jean. It's a really interesting set of issues that you've raised here, and we're definitely going to be diving into the impacts on drinking water systems. So I appreciate you already previewing some of those tools in the toolkit. And I think that's one way that folks can really think about the CERCLA designation is it's another tool in the toolkit as far as addressing PFAS contamination. I think, Christine, going back to you, let's think a little bit more about these community impacts. You both brought up the impacts that PFAS contamination can have on the community. I think it's helpful to level set about the impacts of these particular PFAS, PFOA and PFOS. What are some of the impacts of these PFAS on human health that have been observed here, and why is this so important to address?
Yeah, so I mean, as everyone here knows, right, PFAS generally are a class of extremely toxic chemicals at even very low levels. And PFOA, PFOS specifically have been manufactured and used since the 1940s. So these two chemicals are the most studied and have been the most widely used out of the thousands of PFAS that exist. We know that they're linked to different cancers like testicular cancer, kidney cancer, also respiratory disease, thyroid disease. They've even been detected in breast milk, have been known to cause impaired fetal development, and the list sort of goes on. And additionally, an estimated 200 million Americans are drinking water that are contaminated with PFOA and PFOS. And I'm just going to repeat that. That's 200 million people. So there is no doubt that PFOA and PFOS pose significant risks of harm to our health and, of course, to the environment, including places that we've seen like Tucson, Arizona, Decatur, Alabama, Wilmington, North Carolina, Hoosick Falls, New York. And while PFOA and PFOS have largely been phased out by US manufacturers, they still continue to contaminate our environment and harm communities due to decades of using and releasing them. So they're also still used in products that we import into the United States. So at the bare minimum, we really need to see these two, PFOA and PFOS, being regulated under different federal environmental statutes and certainly including CERCLA.
Yeah, it's interesting because these are such old chemicals and well-studied chemicals. I think they become a focus for other regulations as well. Things like Prop 65 have already been used to target PFOS and PFOA. So you can see if your product has PFOA or PFOS, you get that warning label. And so it's interesting to see how these two chemicals in particular are starting to make their way into our sort of traditional environmental law tools that we have. And speaking of those tools, Jean, you brought up a couple of the examples of tools that folks can use. What kinds of tools have communities been using up to this point to address PFAS contamination? I think there's a few different avenues that people can use, but
Yeah.
what have you been seeing?
Sure. I think the reality is that communities that have been hit hardest by PFAS, including many of the ones that Christine listed, they are the ones that are having to advocate the hardest. You know, they brought class action lawsuits, toxic tort cases, citizen suit enforcement cases under the Clean Water Act and Resource Conservation Recovery Act. They've met with state and federal regulators and legislators, testified in Congress, signed petitions, and they've spoken at public hearing after public hearing. So, you know, the communities are using every single advocacy tool that, you know, that they have access to, and they're having to fight tooth and nail to tell their stories, to also be compensated for the suffering that has been caused to their families, and to make sure that they and their children don't have to live in a future where they, you know, continue to have to drink these chemicals in their water and breathe in air polluted by these chemicals. So, I mean, for me, it's been really incredible to both witness their resiliency and do the work to support this fight. But it's also been really frustrating to see how hard they have to work after everything that these communities have already been through, you know, being exposed to decades of this pollution. And just as one example, right now, folks living downstream of Comores are trying to convince our state, the state of North Carolina, to control other sources of industrial PFAS pollution into the Cape Fear Basin, because these people live at the end of the watershed. So, you know, everything is going to flow downstream, including industrial PFAS pollution. And they've already been, these communities have already been exposed to some of the highest levels in the country. And now they are working in the, you know, the public process for Clean Water Act NPD as permitting, and signing petitions and writing comment letters to ask the state to put in PFAS limits in industrial MPDES permits. And the state has authority to do that now, to consider case-by-case technology-based limits using their best professional judgment. And, I think it's, these communities, it's justified to say that they suffered enough from Comores pollution, and understandably, they don't want to continue to be subjected to other sources of industrial PFAS pollution. So those are just a few of the tools that our communities have used so far, and that they will continue to use moving forward.
Yeah, I think what's really interesting about this process up to this point has been the creativity that you have to employ in order to address contamination. So you've mentioned a few of these Clean Water Act tools. These are sort of bread and butter environmental law tools to get at the industrial discharges. These are permits that at an individual level can be commented on, that can create opportunities for influencing what technologies are implemented. I remember reading that, for instance, the use of barrier technologies to prevent the movement of plumes through groundwater. We're talking about filtration technologies, but also, as you mentioned earlier, discharge, just accounting for your discharge and disclosing the discharge. We've seen those starting to get implemented at the regional level. I think it was EPA Region 1 put out for their draft permits, their model permit for Region 1, the incorporation of reporting for levels of PFAS discharge. So we're starting to see movement in this direction on those activities. But then also, speaking here in Washington State, we actually have a state version of Superfund called MOTCA, the Model Toxic, now I'm going to forget the C, but MOTCA, MTCA. One of the risks of doing this live. And MOTCA is interesting because it has designation of what's known as characteristic pollutants. So things that have certain characteristics, they stay in the environment for a long time, or have flammability issues, or there's a number of sort of, thank you, the Model Toxic Control Act. Thank you, Chad. There's something called characteristic pollutants, and the state of Washington designated PFAS as meeting the characteristics because of their longevity. So we're already seeing the use of these state level cleanup laws to address PFAS. We've also seen the use of tort law that you mentioned, Jean. So there are a number of different mechanisms being brought to bear. Superfund is now this new tool. And Jean, I was curious, are there sort of ways that you're thinking about this tool, or any communities that are particularly excited to get this tool, or how are you thinking about how this fits into your toolkit?
Yeah, thanks. That's a great question. I think it's a tremendous step forward for, clean up these chemicals across the country. And what we've heard is that communities are, very excited that they've wanted this rule for a very long time, because it's such an essential tool for cleaning up the worst sites of contamination that have caused a lot of suffering. We know that this isn't going to make people whole, because that damage is done, where they've already been exposed to decades of these chemicals, but it will give them some, certainty and some relief to know that there is another tool for addressing the most polluted sites, like the Comores site in North Carolina. It can help to ensure that that polluters are the ones held responsible for cleaning up these messes, and not the public. And I think it's important to note that moving forward, this listing will also send a clear message to industries that both manufacture and use these chemicals, and incentivize them to responsibly manage and dispose of their waste. And in particular, it's important for, I think, communities that low-income communities and communities of color, because PFAS are absolutely an environmental justice issue. What we've seen is that communities of color are more likely to have PFAS in their drinking water, and they in low-income communities are more likely to live near industrial polluters, including sources of PFAS, and they're less likely to have the funds to remove PFAS from their drinking water. Those who subsistence fish, also, who rely on fishing for their source of food, are also going to suffer more from the buildup of PFAS in our fish. I think North Carolina, our Department of Health and Human Services recently released a fish advisory saying, certain species of fish in the Lower Cape Fear, you shouldn't eat more than one meal for the entire year. So, that's really, I think, is evidence of just how harmful it can be for to both eat fish and drink water contaminated by these contaminants. So this listing is going to provide some much needed relief to environmental justice communities and other folks that have been burdened by this pollution.
Yeah, I'm glad that you're bringing particular communities to the table as well. I think grounding it in those realities is really helpful. I know our firm has been working on cases related to military sites. And I know that this listing, as you said, it's not going to make everyone whole, but it does provide these new tools and providing levels for the contamination, providing tools for investigation, providing funding for that investigation and remediation. It's going to make a huge difference. Up to this point, there have been investigations taking sampling of groundwater, for instance, or even providing bottled water in some communities. But providing this pot of money, providing these tools in order to access other money to actually clean up the contamination, it's going to be a pretty important tool in the toolkit. It's also just one piece of sort of this broader PFAS puzzle for EPA. I mean, EPA back in 2021 announced this sort of roadmap of what they were going to be doing from an agency-wide perspective, bringing all of these laws to bear. Were there any other laws that either of you wanted to highlight from EPA's activities here? I know, Jean, you've mentioned the Clean Water Act. Are there any other pieces of this that you're seeing as important that Superfund is linking to?
So I'm happy to touch on that. So, given the extensive use and releases of PFOA and PFOS over the course of many decades, right? We're talking about how extensive the contamination has been. And, I think it's good to highlight that even Biden felt compelled, right, to make commitments during his presidential campaign to address the PFAS crisis. And so there's really a huge need for this class of chemicals to be regulated under different federal environmental statutes. And, as I mentioned earlier, by listing PFOA, PFOS as hazardous substances, EPA can finally, begin cleaning up some of those most contaminated sites across the country. And also, I think this definitely does correlate to other, potential regulations and other statutes. We already have, for example, hundreds of PFAS that are listed on the Toxics Release Inventory, which is a program under EPCRA that requires facilities who are operating, using, or processing these TRI-listed PFAS to annually report its releases that exceeds a certain threshold. So this is a very useful tool. It functions differently than CERCLA, but both help gather more information for public and agency awareness so that, we know and understand where majority of these releases are. Also, we're waiting on the drinking water standards rule, which everybody is, sort of on the edge of their seat waiting for, which will set the first ever federal standards in drinking water for PFAS, for 6 PFAS, which also include PFOA and PFOS. And, we've also seen the EPA has proposed to designate 9 PFAS, including PFOA, PFOS, as hazardous constituents under RCRA, which would expand EPA's authority to address PFAS cleanups under RCRA's corrective action, and would really help supplement cleanups under CERCLA as well. So the CERCLA designation is one aspect, but an extremely important one. And I'll just to go back and touch on the drinking water standards. The fact that EPA is proposing a maximum contaminant levels of 4 parts per trillion for PFOA and PFOS specifically, which is incredibly low, is just another reminder of how toxic these 2 PFAS are at very low levels and why remediation efforts are so badly needed.
Yeah, I'm glad you brought us back to the drinking water issue. It segues extremely nicely to our next topic, which is to talk a little bit about impacts on water providers. The safe drinking water standard is extraordinarily low, and a future webinar will focus just on the drinking water issue alone, because I think it warrants its own discussion to talk about the technologies that can be brought to bear to reach those levels, what it looks like to address this kind of contamination in drinking water. And there's been a lot of activity. We received some questions in the Q&A, and just to plug that again, don't be shy about putting things into the Q&A. It's shaping our discussion even as we go, and we'll be addressing questions at the end. But there's been a lot of political activity around the idea, the fears around drinking water providers that are taking on PFAS contamination, and the potential that these water systems are having to deal with CERCLA liability, whether it's through the presence of PFAS in their source waters, the presence of PFAS in the water that they're serving to customers, the presence of PFAS in their biosolids after cleaning or after separating and going through their publicly owned treatment works. There are a lot of potential concerns here relating to PFAS, and the term passive receivers, which has been applied to drinking water providers. Let's talk a little bit about how drinking water providers can approach this issue, or how utilities generally can approach these issues. Jean, you've been working with a lot of utilities here. How can utilities approach this issue and limit their CERCLA liability for PFAS contamination?
Yeah, thank you, James. That's a fantastic question. Apologies. And I just want to, as an initial matter, I want to point out at the outset that utilities are not going to face significant CERCLA liability for PFAS. And that's because EPA has made it very clear that the agency doesn't intend to go after utilities. And this is in line with how EPA has acted in the past. The agency has very rarely gone after utilities because they are usually minor contributors and they have limited ability to pay. And they also won't be unfairly targeted by third parties because EPA can protect them through settlements, as they've done for the past 40 years. In fact, EPA has said that they are going to proactively protect utilities that are concerned about cases brought by third parties. So, I think the concerns brought up by utilities, a lot of them have been overblown because, CERCLA has been around for many decades. And they haven't, utilities haven't been, unfairly targeted by the statute and by EPA enforcement in the past, and they won't do so here and in the future. But even so, they can begin to take steps now to limit any potential liability. So CERCLA excludes federally permitted releases, including discharges that comply with the Clean Water Act and PDES permits. So entities like wastewater utilities should make sure that they are first and foremost in compliance with the Clean Water Act and their NIFTs and their MPDES permits. So they can do this in a few ways. First, they should disclose any PFAS discharges in their permit applications so that they make sure that those discharges are covered by their permits. And then second, wastewater utilities should be using their Clean Water Act pretreatment authority to identify and control any industrial sources of PFAS pollution. This would mean that industries would be removing the PFAS before they send their waste to the wastewater treatment plant, and that the chemicals never end up in the city sewer system in the first place. Because of the way CERCLA functions, complying with the Clean Water Act's permitting scheme will help shield these utilities from liability. It also will send a message to EPA that these utilities are acting in good faith. You know, this is something that EPA has considered and will continue to consider when making enforcement and settlement decisions under CERCLA. And by taking these steps, utilities would be showing to EPA and the public that they are doing what they can to keep PFAS out of their wastewater and out of their sludge and biosolids, and that they are doing what they can to protect our communities from these chemicals. So there are a lot of things that even though utilities will not be subjected to, you know, outrageous CERCLA liability with this listing, there are steps that they can begin taking now to limit any liability.
It's a really interesting set of tools that you're describing that sort of get at the front end of the PFAS inputs into these systems. I guess it might be helpful to talk through, like, are there any examples of this that you've been working on that you'd like to highlight? Or yeah,
absolutely. Yes, in our region, we've done a lot of work with wastewater plants to get them to use their pretreatment authority to control both PFAS and other industrial pollution. And the state of Michigan, as some of you might know, has also done this really successfully through their industrial pretreatment program. To just give one example, in our region, the city of Burlington, North Carolina, the city operates a wastewater treatment plant that discharges into the Haw River watershed, which is the drinking water source for many communities, including the town of Pittsboro. And this is a really small rural area. Pittsboro only has about 5,000 people, and they don't have the resources to easily install drinking water treatment. But they have been suffering from PFAS. Their levels in their blood are comparable to those living downstream of Comores. And several years ago, we discovered that the city of Burlington was a huge source, that there was PFAS in their wastewater from their wastewater treatment plant and in the sludge that they were land applying. And so we worked with the city to investigate their industries to try to find out the source of the PFAS. And it turned out that it was almost all coming from one industry, a facility that was releasing PFAS at levels as high as 10 million parts per trillion. That's 10 parts per million. And when you're thinking about, drinking water health advisories that are 0.004 and 0.02, 10 million parts per trillion is just outrageous. But once Burlington put the pressure on the industry using the city's pretreatment authority, the industry committed to phasing out PFAS by January 2025, which is the start of next year, and to changing its processes in the meantime to both treat and control its pollution. So we've learned a lot from our work with Burlington and other cities, and I just want to point out a few key lessons that we've learned. First, the worst of the PFAS pollution that we are seeing in our rivers and our drinking water sources comes from industry and not from domestic sources. What's trickling from our washing machines is not going to show up at levels of 10 million parts per trillion. It's not even comparable. Second, a lot of times, what we've discovered is that these industries don't even need to be using PFAS in their processes. And a lot of times, once they get pressure from a city that doesn't want to accept PFAS into their sewer system, the industry finds a way to eliminate these chemicals. That's what we saw in Burlington, and that's also what we saw from our advocacy in Tryon, Georgia. And then finally, and perhaps most relevant for this this conversation is that the solution doesn't have to be expensive for wastewater utilities. They can put all of the burden on the industries that use and release these chemicals. They can require the industries to conduct the sampling, to identify themselves as sources, and they can require the industries to install the treatment technology. And that's, of course, far more cost effective than installing treatment at the wastewater plant, which, you know, the wastewater plant might be dealing with, some of ours have 60, 70 millions per gallons per day, or a downstream drinking water utility, which also has, you know, a huge volume of water that they are dealing with. Whereas the industry might be dealing with just you know, a couple 100,000 gallons per day. So, you know, it doesn't compare in terms of the cost to treat. And of course, it's also what's fair, because it means that the polluter is the one footing the bill for cleanup, rather than the city that's operating a wastewater plant, or then, you know, downstream drinking water utilities.
Thanks so much for that explanation of the pre-treatment authority, and talking a little bit about what kinds of tools there are available for these drinking water systems. I mentioned earlier that this has gotten a lot of attention as an issue. There's been certainly a lot of regulatory comments on the subject, both from drinking water providers, but from other folks who receive potentially this kind of contamination, places like landfills, places like so landfills, drinking water systems, agriculture as well, where the application of biosolids that are potentially contaminated takes place. As a result of this activity, both from comments, but political activity, we've seen, I appreciated there was a question along these lines, that this is still a timely panel, because just last week there was a Senate hearing on the topic, which doesn't always happen. Christine, to bring you into this discussion, could you talk a little bit about the possibility of congressional action here? I know there's a lot of interest in potentially addressing these issues at the legislative level. Would you mind talking a little bit about that?
Yeah, so we, you know, just to quickly touch on the hearing that was held last week by the Senate Environment and Public Works Committee, which was on this rule, and many of these conversations came into play, in addition to, you know, potential exemptions that certain industries are seeking. And, you know, we did hear from witnesses representing these utilities, you know, making the arguments essentially that once the rule is implemented, that they'll be on the hook for significant liability costs, and that, you know, ratepayers will also be negatively affected. But we just really have no reason to believe that this designation is somehow going to completely shift and make unmanageable what drinking water and wastewater utilities have already been doing, which is managing and treating other hazardous substances every single day, and have been doing so for the last 40 years. You know, and ratepayers are already being impacted because people's lives are at stake. And that's the most important piece in all of this, especially, as Jean mentioned previously, for low income and communities of color who are most impacted by PFAS. But, you know, to legislation specifically, we have seen a few bills be introduced by Senator Lummis, and that was last year. And that would essentially provide exemptions for specific sectors. And those were introduced in the Senate. They have not been passed. But this is certainly an ongoing issue. And, you know, with the Senate hearing, again, you know, I mean, the topics of exemptions did come up, and there's still a lot of sort of back and forth, I think, between members about what the real likelihood will be for these sectors to be liable for cleanup costs. And we can't necessarily predict what will happen as far as the potential exemptions. But, you know, what makes, I think, the issue of PFAS as a whole so unique is that it is a bipartisan issue, right? This, PFAS impact both blue and red states. So it's something that members are very much invested in on both sides of the aisle. And, I think we can all agree that we absolutely need to reduce and eventually eliminate all PFAS exposures. But as we work towards that, designating the two most notorious PFAS under CERCLA will be a huge step forward and will provide a comprehensive structure where responsible parties are, paying for long-awaited remediation. And our justice has dedicated a lot of our time, along with partners and other environmental groups, to oppose those exemptions. I think it's very important, and Jean spoke to this a little bit, right, that we certainly do not place utilities in the same category as PFAS manufacturers or major industrial users, but they do have a role to play. And there are already tools that they can and should be using to protect themselves from potential liability. So, again, EPA has already stated what it intends to focus its enforcement on and also provide contribution protection, and has no intention of going after sectors like drinking water or wastewater utilities. And there's also, preemptive, carve outs that I think can be really dangerous, because that will potentially open the door for more industries to come running and seeking exemptions, and will hinder communities from finally getting some relief after so many years of, exposure, when we know that companies were intentionally concealing evidence about the toxicity of these two chemicals in particular and the dangers caused by their exposure. So, I think overall things are somewhat in limbo right now, congressionally speaking, but because we anticipate the final rule to come quickly, we also expect that these conversations will continue on Capitol Hill for the upcoming months.
Thanks, Christine. And to make explicit what both you and Jean have referred to, EPA did announce its settlement policy and enforcement discretion, sort of where it sees its role in this being. Jean, would you mind just talking a little bit about what EPA has sort of announced here? We've danced around it, but I just want to make it a little bit more specific and targeted.
Yeah, I think, we saw back in the EPA's listening sessions in March of last year, as Christine mentioned, they announced that they don't intend to go after wastewater and drinking water utilities, and that they're going to put out a memo on this. They also made it clear that they will protect utilities from liability through de minimis settlements, and that they will go as far as to proactively protect them, those that are concerned about cases brought by third parties. And we've talked with a lot of EPA folks about this, including Cynthia Mackey, who led and worked on CERCLA cleanup enforcement at EPA for many decades, and she also submitted testimony during the Senate hearing last week. And she's confirmed all of this with us and reassured us that, when EPA puts out an enforcement memo like this, that they are going to follow it, and that utilities will be able to count on EPA to focus on the worst sites and the worst contributors. And that's not going to include, wastewater and drinking water plants that are responsibly handling their waste, especially where the wastewater utility is using what authority they have under the Clean Water Act to control any industrial PFAS pollution. So yeah, we, as Christine mentioned, there's no reason that that CERCLA won't function as it has in the past, and that, that it's, all of a sudden expose utilities to a ton of unprecedented liability.
Yeah,
I mean,
go ahead.
I just wanted to add that, I think that public water systems really should be celebrating the benefits that the rule will bring, because right now for them, the status quo isn't good. We have industrial PFAS pollution getting into our rivers and our drinking water sources all over the country. And these drinking water utilities are having to install $50 to $170 million treatment systems. We've seen this in Brunswick County and Wilmington, North Carolina. But when this rule comes out, it's going to send a clear message to polluters that, this isn't that they could be on the hook, and incentivize them to get their act together and to prevent future releases. So that's going to be a huge step for drinking water utilities that are downstream of all these, all of this industrial pollution, and, for these utilities that don't want to be spending millions of dollars to clean up this stuff.
I think it's interesting, and I think the questions that we're receiving indicate a certain level of anxiety around about the risk involved. An enforcement memo is definitely assurance, but the question is it enough assurance? Is it enough? And I will agree with Eugene, like the EPA has been really consistent in their message here that they plan to use their settlement authority, which was raised by one of the questions in the Q&A. Again, plugging the Q&A function here, feel free to submit. Someone asked whether settlement authority could be used to protect drinking water systems from third-party litigation that otherwise, just because EPA is not going to enforce, doesn't mean third parties couldn't enforce against the drinking water system. EPA has made explicit in their listening sessions, in their discussion sessions, an intent to use that settlement authority to inoculate drinking water systems from that kind of liability. So it's a really interesting time for this rulemaking, really interesting set of policy questions to be asking, especially because, as Christine mentioned, there's the possibility that others might seek this kind of exemption. I know that there are a few bills that have been offered by Senator Lummis, including coverage for agriculture, for fire suppression, for airports. So there are a broader set of industries that are also concerned about the potential impacts of Superfund designation. And it's going to be interesting to see how it all ultimately shakes out here. Before we dive into any of the questions in particular, any sort of concluding thoughts here, Jean or Christine, on the designation or on the enforcement discretion here?
Yeah, I think I'd just, piggyback off of a couple of things that were already mentioned, but, I think one point that is important to note is that EPA is also offering proactive protection. So if, utilities are concerned about potentially being roped into third-party suits, they can go to EPA in advance and allow them that time to facilitate protection. And they can do that on day one, from the moment the rule is implemented. And I think, again, we've seen utilities managing and treating for other hazardous substances every day. So this is not somehow a new process. And we don't believe that adding PFOA and PFOS is somehow going to completely shift the way that, the liability works under the statute as it has for the past 40 years. There won't be a shift in terms of, if we enter a new administration, right? We've heard some concerns about that, and will the enforcement policy change? And again, CERCLA has been intact since 1980, and there's just no way that it could have worked effectively if the liability policy just changed based on every single administration. And I think ultimately the asks are also just premature, right? I mean, we hear the concerns. Again, we understand that they are, these utilities are in no way comparable, right? They're not significantly releasing these chemicals, right? And the way that manufacturers are. So we completely understand that. But, you know, we feel like this is early in the game. We have not seen the final rule. It hasn't been implemented. So it's unprecedented to now, you know, come to Congress and say, hey, we're concerned about this rule and these are the hypotheticals, but we don't really know how things are going to play out. And we have EPA very clearly saying, this is why we're taking this stance on our enforcement discretion. This is why we plan to settle out, why we plan to provide contribution protection. So, you know, we just really think that we should allow this to sort of take its course. And then, you know, if EPA doesn't do what it says it's going to do, let's come back and have the conversation. But again, I think everyone here can agree that we really need to take, you know, drastic steps to start reducing exposure and eventually just completely eliminate exposure to PFAS.
Jean, any other sort of concluding thoughts here on designation?
I think Christine wrapped it up pretty well. Yeah, thank you.
Well, looking at the chat and the Q&A, we've received a few questions. I think we've got time for maybe one or two. Jean, there was a question relating to the pretreatment authority that you were describing. Do you mind talking just a little bit about where it's rooted and what it, I guess just describe a little bit about where it comes from.
Right. So a lot of the regulatory provisions are in 40 CFR section 403.8. And really the regulations make clear that, sorry, apologize, that municipalities are required to fully and effectively exercise and implement their authority to control pollution that they aren't able to treat for, like industrial pollution, like PFAS. And they can do that in a lot of different ways. They can put in pretreatment permit limits. They can put in pretreatment conditions into permits for industrial users that, like Burlington has been doing, has done for 1,4-dioxane, that they've required an industry that was responsible for releasing that pollution to, you know, put together a plan to control that pollution, to monitor for those pollutants. And Burlington is also looking at doing this for PFAS as well. So they can do it through permits, orders, other tools in the pretreatment, in the municipality's pretreatment authority. They can use compliance schedules to give industries some flexibility if they need time to install technology. They can require self-monitoring reports, and then also a whole bunch of authorities around inspection, surveillance, and monitoring that the city can go in and make sure that the industry is properly managing its waste. So I think when Congress and EPA, designed the pretreatment program, it was with the understanding that these wastewater treatment plants are not built and equipped to handle industrial waste like PFAS chemicals. And so that's why municipalities are given such broad leeway, such broad authority to do, to control that industrial waste through the pretreatment program. They were never meant to just allow industrial chemical pollution to flow straight through all of these wastewater plants and into our drinking water sources and rivers downstream. So what we need to see is for these utilities to begin to use that authority so that, so that our communities don't continue to be exposed to this pollution.
Thank you so much for that. That's really helpful background for folks. And I'm going to plug in the chat. I had referred earlier to a Region 1 general permit. This is the final medium wastewater treatment facilities general permit for Massachusetts, because the Commonwealth has not taken authority under the Clean Water Act. So EPA does their clean water permitting. There's some interesting content in there about pretreatment authority and looking at how to account for upstream inputs into the drinking water system or into the treatment facility, accounting for it and then planning for reductions. And this specifically addresses PFAS. So we're seeing this example spread, and it's a really interesting mechanism to think about. While looking at our time, and since we already concluded, I think we have to wrap up here. I want to thank you both so much for giving your time, giving your expertise on the subject. Really grateful to have you here for the monthly PFAS briefing. Thank you both so much, and I can pass it back to Madison to wrap us up.
Thank you so much. I want to give a huge thank you to James, Christine, and Jean. We're so grateful to them for taking the time to join us this afternoon to have this important discussion. Thank you as well to our audience for tuning in and for asking some great questions. As a reminder, this series will continue throughout the rest of the year. We'll continue to be back on the 4th Tuesday of each month at 12 p.m. Eastern for new PFAS briefings. We're excited to continue to provide ELI members with the latest updates in PFAS regulation, as well as unique special topics each month. Please remember to register on the ELI website for all future sessions. Additionally, we encourage you to check out the PFAS test desk book if you've not already. Sarah's put the link to that in the chat as well. With that, the session has come to an end. We'll see you next month for a discussion about Ohio personal injury PFAS litigation. Thank you so much, and I hope you have a great day, everyone.